Welcome to the free immigration help channel. Today is April 21st, 2024, and we are getting into the volume 199 of me answering your immigration related questions. As always, before beginning this video, I'm gonna mention, as I mentioned in every video on this channel, I'm not an immigration attorney. This is not legal advice. All the information provided in these videos or this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first question coming from Morsane Walters 8206. Morsane, thank you very much for being publicly subscribed. Appreciate that. Good day, sir. I am F1 category and my priority date is 12 February 2015. Is it possible that when I go to the state, I can get married in a month time or two? I am from Jamaica. Great question, and yes, absolutely. The reason why Morsane, and I hope I'm pronouncing your name correctly, is asking that question is because if you are in F1 category, you're an unmarried son and daughter over 21 of a U.S. citizen petitioning for you. Your parent is U.S. citizen and they're petitioning for you, and you are unmarried son and daughter over 21. If you were married, then the F1 converts to the F3, which is quite a lot longer wait. Let's take a look at the visa bulletin and see by how much. By 5 years, which is very sad. That's what we have to deal with, and that's the situation that US Congress, Department of Homeland Security, whoever is involved in all of this lawmaking, legislative branch, unfortunately, that's what they created. That people, they cannot, do the natural things like get married, of what they have to deal with in case if they do. And that's another 5 years of waiting. It's really unfortunate. But Morsane, it's yes, absolutely, you will be completely fine. And yeah, definitely if you can wait, because you are in February 2015, so you are already you're already current, and you've been current now for I'm not sure how long. What exactly when visa bulletin reached February 2015. I know sometimes it's not an indication, because if you look as of right now, you can say Morsane been current from February to July 2015, which is what is in May 2024. It is, let's see, February, March, April, May, June, July, 5-6 months, right, roughly. But the thing is, visa bulletin doesn't always move 1 month every month. Sometimes it moves 3 months, 6 months ahead, which is great. Sometimes it doesn't move, sometimes it retrogresses. So it's not an indication. So Morsane could have been current for longer. But because you're already current, because you should do, you should be getting your interview, I would say, potentially by the end of this year. Jamaica, Kingston, Jamaica, I know they're a little bit busier, the US Embassy over there. But definitely, yeah, you're almost there. Once you get your I-551 stamp, the immigrant visa, once you come in with that immigrant visa into the United States, immediately it converts to the permanent resident, temporary permanent resident card, and that's it. You're already a permanent resident of the United States of America. And then you can, get married and do the rest of the stuff. So yeah, absolutely. Okay, let me post the answer here, and we're gonna move on to the next one from D.H. Rufshan. Sorry if I'm mispronouncing the name. Hi, thanks for this great video. I have a quick question. My I-130 F4 category was filed by my sister in September 2017. The status will show case was received. Case processing time shows 49.5 months for California Center, but it has been now over 6.5 years. The case is still not approved. Could you please let me know what needs to be done to expedite the case? Okay, great question. Thank you very much. So unfortunately, whenever it comes to expediting the case, really there is not much point. The only expedited processing that really exists and works for I-130, petitions, family reunification petitions, is when the immigrant visa is already available. That means when the priority date is already current, when you're already documentarily qualified. And it is only for the situations where there is medical emergency, some kind of life-threatening emergency, which became recent update, because before you could file an expedited request in situations where a child was aging out. But now it's only for medical emergencies, unfortunately. So really, and I can completely relate because I personally have the F4 case filed for my brother, and same thing. It has been sitting with USCIS. They haven't even reviewed it yet. But the reason for that is because the long backlog that is on the F4 category in general. So it was filed by your sister in September 2017. So let's take a look at the visa bulletin and see what's going on for the F4. Okay, so did you specify your category? I mean, not the category, the chargeability area. So you didn't. So I'm gonna assume you're in all chargeability area. So for all chargeability right now, it's on July 2007, and your sister filed it in September 2017. So roughly there is another 10 years of backlog to wait. So that's really why USCIS, they don't even get to these petitions because of how much backlog there is. They get to them closer to when the priority date is becoming current. So the processing times on the USCIS website, they constantly update, and a lot of times they are outdated, so they're not an indication. So really there's not much to worry about at this moment, honestly, because there's still a lot of time ahead. So yeah, unfortunately, I wish I could give you better response, better news. I personally completely understand because I have another 13 years to wait on the petition that I filed for my brother. So yeah, I completely understand this is frustrating. This is a lot of time to wait, but that's the way it is, unfortunately. All right, let's move on to the next one from David Smith. Son, 22, great video, but need your assistance if possible. My wife's IR, also immediate relative immigrant visa, was documentarily qualified on October 26, 2023, priority date September 27, 2022, and have been waiting for an interview at the US Embassy in Manila. What is the interview date ETA? Okay, so the good news is that it is immediate relative category. So as soon as it was approved by USCIS, the immigrant visa was already available. The only reason why you're still waiting, September 22, we are now in 2024, I know it's a long time, is because in Philippines, Manila, Philippines, US Embassy, they are quite busy. Immediate relatives, they still are given more priority, so I'm sure most likely by the end of this year you're going to have your interview scheduled, and it is already scheduled. That's the thing, these interviews are already scheduled. You just don't know it yet because you can only announce the interview 30 days before the actual interview date. Very rarely they announce it 60 days before the interview, but most of the times it's 30 days. So let's say, for example, the wait time from when the immigrant visa becomes available or the priority date becomes current, which is the same thing. It's just the differences in family preference categories. You wait for the priority date to become current because there's a backlog. Immediate relative category, you don't wait for the backlog, but both of these categories, whether the family preference or the immediate relative, both of these categories, they equally deal with the wait time in line for the actual interview after their immigrant visa becomes available, after the interview is scheduled. So what happens is the US Embassy, they receive the case from the NVC. They say, okay, yeah, the beneficiary is documentarily qualified. That's it. Schedule the interview. The immigrant visa is already available in your case because it's immediate relative category. They look at their scheduling. They see that the nearest appointment for the interview, Manila, Philippines, easily about 2 years, easily, because I have some people saying that they've been waiting in family preference categories for 2.5 years on this channel. At least that's what I know from comments. So they schedule this interview 2 years ahead, but you don't know it yet, and you're not going to know it up until 30 days. I know it would be a lot nicer, and there is a conversation that they might do that, and I really hope that they do, because it's gonna make it a lot easier for people. Because it's easier to wait for 2 years knowing that, yes, September 2025 I have my interview. Yes, it's annoying that I have to wait, but at least I know that it is September 2025 when I have the interview. For example, rather than waiting up until August 2025, being completely in the dark, not knowing when the interview is going to be scheduled, and then, they do it because you have to do the medical examination within the 30 days. But honestly, they can still keep the same rules. Just, do medical examination within the 30 days. What doesn't really matter. If you know, it's just better for everyone that, applicants, the petitioners, beneficiaries, they don't stress about it, and they don't have to call, they don't have to bother U.S. Embassy, which is one thing that you can do is you can reach out to the U.S. Embassy in Manila and you can ask them and see if they can give you the date, because over the phone it's unofficial announcement. But the thing is, most of the times they say we can't give you that information. So again, it's kind of, in most of the situations it's pointless to call them. But if you really are, if you really want to, it's worth a shot. Okay, let me post a response here, and we're gonna move on to the next one from Dante Alipio 9398. Hi, your video clip on how and what to do on filing Form I-539 were very helpful. Glad it was helpful. Thank you for your advices. I would like to share information and ask you the following. 1. I filed my I-539 to the correct address with a fees of $370 45 days before the expiry date of my wife B1, B2 visa. After a month or more, my wife, got the Form I-797C notice of action. Perfect. Now my concern is her B1, B2 visa is about to expire in a week from now, but the application for the extension is still on processing till this date. Having said that, what is the best option we can do, if any, out there that we can consider? Also, in our application, our reasons for our request for extension was medical reason with the doctor's note, laboratory works appointment, etc. Okay, Dante, great question. Thank you very much for asking. So it seems like you do have, a very strong, very valid reason, and you had the evidence to corroborate that, your request is completely legitimate. So there shouldn't be any problems with the approval of the extension. Here is the thing though, a little bit of kind of a culprit with these extensions is that while you're waiting for this extension to be approved, technically you do get into that out of status category where now your duration of stay has expired, and you are now on the expired duration of stay, which is definitely not very good thing. It's a little bit scary, and after it expires, definitely it's not recommended leaving the country, because if you leave the country, your I-539 is considered abandoned. All right. So if you consider leaving the country before it expires, then it's not going to be a problem. But if you leave the country after the duration of stay expires and your I-539 is not approved yet, that is a problem. So you definitely don't want to be in that situation. Now, once the I-539 is approved, and in your situation, I say chances are, there's always a chance that something might happen and they might not like something, or there's always a chance, because it's at the end of the day, it's at the discretion of USCIS. But once it is approved, that's it. All your stay here, even after the duration of stay expired, everything is good, no worries at all, because all this time that your petition was pending with USCIS, after the approval, it becomes completely fine, completely legitimate, no problems there whatsoever. So it can be pending for another 6 months, it can be pending for another year, and your wife will be for 6 months, for a year, out of status up until the I-539 is approved. And like I said, most likely it's going to be approved, shouldn't be any problems, especially in your case, because you have, strong reasons for that and you provided the evidence for it. So there shouldn't be any problems. But still, and whenever it comes to I-539 in general, my recommendation is if it's not as if you have an opportunity to leave the country before it expires, it is better to do that, because you put yourself in a situation where you're now out of status and you're 100% relying on the approval FF39, and it becomes, if it is not approved, if it is denied, then all of this time that you have been here is now considered past the duration of stay. Definitely not a good situation. Again, in your situation, most likely it's going to be approved. Shouldn't be any problems, but something for you to keep in mind for sure. Okay, let me post a response here, and we're gonna move on to the next one from Raghubir Gupta. Can F4 documentarily completed by NVC be converted to parents sponsorship visa? If eligible to do so, what is the procedure? Thanks. Raghubir, sorry if I'm mispronouncing the name. So F4 is siblings. So US citizen sibling petitions for sibling outside of the United States. And well, it definitely cannot be converted to parents sponsorship visa for sure, because parents, that's immediate relative category. When the US citizenship petitions for parents, that is immediate relative category. And there is really no point of doing that, because I'm not sure how even it is. How is it possible? Who would become a parent and convert it to parent sponsorship? The only thing that you really can convert is F2B to F1, because a permanent resident spouse, well, not in this case, not spouse, because it's going to be a parent petitioning for son or daughter over 21, F2B, and then the parent becomes US citizen, and then it converts to F1. But yeah, no, it's not possible. And if you can, please clarify what you mean, and because it's siblings, I'm not sure how there's like a parental relationship there. All right, let's move on to the next one from Fanzila. Thank you for the video. I have questions regarding my sister's green card and her spouse coming together. I petitioned for my sister. It took a long time, but finally got her family, got the interview date. Awesome. Her husband and 3 children are on the application. What kind of questions and paperwork should they be ready for my sister and her husband? Also, can consulate give visa to her and her children, but not to her husband? Her husband has business in the home country, which will take some time to wrap up, which they plan to do after the permanent green card. Can consulate use this against them for immigration? Great questions. Thank you for asking. So here's the thing, that yes, issuance of immigrant visas, absolutely, it's at the discretion of the consul of the US embassy. So there's always a chance that they might not like something. There's always a chance. As far as the business goes, that's completely fine. They understand that you do have time, you need time to sell the property, to wrap it up, to close the businesses, do all of that before you actually move. That is completely fine. In fact, if they are already thinking about it, that is a good thing, because they genuinely are showing the intent to immigrate, and that's one of the topics that the questions mostly are about whenever it comes to relationships, like in your situation, it's sister. So when you petition for your spouse, that's when these questions come up that are, sometimes not very nice questions, where they test their relationship, whether their relationship is real or not between a husband and wife. But when it's siblings, when it is parents, kids, there is no trick questions about the relationship, because you show the relationship with paperwork. Hey, look, it's it's a birth certificate. That's my parent. That's my sister. Yeah, what? Not a real sister? Yeah, of course it is. It's husband and wife, where they can look at and say, oh, are you really husband and wife, or you're not planning anything? Because there is fraud, unfortunately, a lot of fraud whenever it comes to that kind of stuff. So most of the questions will be concentrated on the intent to immigrate to the United States, and really that's what most likely gonna be asked, like, What have you done to prepare to immigrate to the United States? What are you planning to do when you move into the United States? What are your kids? What are your children going to do? Are you planning to give your children to the school? Did you find a school? Which state are you planning to live in? Are you planning to live with your brother for a certain amount of time? Just a basic stuff like this. To show that yes, they thought about it, that they are planning to immigrate, and it's not just, something. But as far as, as her husband, of course, he's a derivative beneficiary, just like kids. So unless there is some kind of serious reason, like, some kind of record that came up or something, there shouldn't be any problems. And they should be getting through and getting their immigrant visas without any issues. But I would really appreciate the update once they do get that. It's really nice. I mean, it's great to get the questions on this channel, but I also really appreciate the resolutions. And also, if you can, Fanzilla, if you can, I'd really appreciate what was their wait time for an interview, which country, and what's the wait time, because a lot of people who are watching, they're waiting for their interviews to be scheduled in different countries, and the best source for that information on how long I'm going to wait for my interview in a certain country is someone who is from that country who already had their interview scheduled. So if you can share, that would be really, really great help for everyone. All right, let's move on to the next one. James says, thanks, sir. You're very welcome, sir. Glad this was helpful. Moving further to Saibu Oluwabimpe. Sorry if I'm mispronouncing. Hello, priority date is September 2022. Currently, my son is 22 years. By September, do you think he will age out by the time of approval? Thanks. Okay, so it really depends, because if your son is 22 years old and the priority date is September 2022, here's the thing. If you have been US citizen on the day of the petition, then your son's age would have been 20, wait, sorry, my math is horrible. So 2022, 2 years ago. So 20 years old he would have been. Maybe even less. No, 20 years old. And his age would have been frozen because it's immediate relative category and you're a US citizen. But if you're permanent resident petitioning for your son, it would have been F2A. And let's take a look at F2A and see what's going on. So I'm going to look at all chargeability areas. So it's June 21. So it's June 21. So there is still about September 22. So there's still about September to June, less than a year. July, August, so like 9 months. There's still about 9 months, roughly, before the priority date becomes current. And then, of course, there is some wait time for an interview. So 9 months. Man, it's getting close. It's getting close because it's September 22. If the priority date, I'm thinking your petition, USCIS petition, I-130, that is, would have been approved within like 6 months to a year max. And if you are in F2A, if there is an F2A category, in that case, you can only subtract that 6 months to a year. So not a lot of time to subtract for the CSPA. So it's a tough one. So if you can, I would really appreciate a little bit more details. Let me know the category so that I'm not doing the guessing. Let me know the chargeability area. And also, put the priority date, your son's year of birth would be helpful, and then how long the petition was pending with USCIS, because that's the amount of time under CSPA that you can subtract. Hopefully we don't have to do any of that. Hopefully this is an immediate relative category, because it doesn't matter. If you're petitioning for your son or daughter, you're a US citizen, and you're on the date of the petition, which is the priority date when it is received by USCIS, your son or daughter are still under 21, even if it's few months, that's it. Once they receive and accept the petition, the age is frozen. It doesn't matter how long it takes. It can take a year, 2 years, 3 years, 4 years. It doesn't matter. The age is frozen and it's still immediate relative category. So hopefully it is the case for you. But if not, then please clarify some of the details that I requested, and I'll try to look at it again, and we will do a little bit more accurate calculations. But basically, for everyone who's interested in CSPA, however long the I-130 petition is pending with USCIS, not the NVC, not the documentary qualification, just the USCIS. That is the amount of time that you can subtract from your kid's age on the date of the interview. And if after the subtraction, if it does go under 21, then yes, they're still considered as a child under that Child Status Protection Act, CSPA. Okay, let's move on to the next one. From Azan Shahzad 9612, please sir, make one video on I-129 form filing for E2 visa. I checked whole internet, no one make any video. Me and whole world is thankful to you. Azan, thank you very much for request. So I do have the video on I-129, but it's not, in that example, I show, I believe it's H1B that I'm making as an example in I-129 video. But again, the process is very simple. You're basically just filling out that particular section of the I-129, because I-129 itself, it's the same for everyone. And then depending on which particular category, which particular visa you're applying for, you find that page, and there's only 1 or 2 pages max per category. You find it in the application and you fill it out. Pretty straightforward. So check out the video on I-129 that I already have, but I will take a look at it and see if I can make a separate video specifically on E2. I believe that's treaty. I'm not as familiar with those, but I'll take a look and see if I can make that video as well. All right, moving further to Mit Patel 6452. Thanks for your channel, sir. It is indeed helpful. Glad you found us helpful. Can you also explain adjustment of status process after filing I-130? Okay, case F2B, priority date May 03, 2019. Parents were green card holder at time of filing petition. Now they're citizens. I came here on F1 student visa in 2017, and till then maintaining my legal status as an F1 student. Can you enlighten some future estimate updates? Thanks for your help. Mit Patel, that is the best really case scenario, and that's what I really recommend to everyone. If you can find a way to be with your relatives, meanwhile, while the petition is pending on some kind of non-immigrant status, whether it's a visitor visa, whether it's a student visa, whatever it is, this is the best case scenario that you really can do, because you can comfortably and peacefully wait for your petition, for the backlog to go through, while you're with your relatives, while you're with your family. So that's the best case scenario, mate, for sure. As far as your question regarding the adjustment of status, I would recommend you check out the video that I have on I-485. I did not make it specifically. I think I made it based on selecting based on approved asylum or refugee application, but that's really the same process. The only thing that you're selecting, and I'll show you, this is the official government website for USCIS. I'm sure you're familiar with this already, but on the very front, under the forms, the very first application, the most accessed forms, I-485, application to register permanent residence. So I'm gonna click on the I-485 itself, and I'll show you there is this. I explained in the video 485 how to fill it out, what to fill it out, very straightforward, nothing crazy. But there is this particular, there you go, application type or filing category. In your situation, this is what it's going to be. Immediate relative of a US citizen, Form I-130. Well, actually, in your case, it's not going to be that, because you're not an immediate relative, because you're in F2B. So, other relative of a US citizen or relative of lawful permanent resident under the family-based preference category. So, for you, it's going to be this. And that's really it. So once your immigrant visa becomes available, you most likely will get a notification from NVC saying, hey, where do you want us to schedule? Because I'm pretty sure that when the I-130 was filed, it wasn't specified where it's going to be processed. So you will just have to request processing within the United States. And when you do that, they ask you to fill out that I-485. So you do that and you file it, and they schedule your interview here in one of the what do they call it? Immigration field support. No, it's application support center field offices. And yeah, that's really it. You go for an interview here, do the medical examination, obviously with the I-485, and you're doing pretty good. You're pretty on point considering your situation. All right, so let me post the response here, and we're gonna move on further to the next one from Raina Naomi 5538. Hello, I'm from Bangladesh. My priority date will be current in May. My priority date is June 11, 2007. My documentary qualification date is January 5, 2021. When will I get my interview letter F4? Okay, so F4 category. And it looks like, let me double check if it's the same one. My priority date will be current in May. After that, how will it take to... Okay, so once the priority date becomes current, once the immigrant visa becomes available, that's when the US Embassy, they schedule the interview. So Bangladesh, I know that US embassies, US Embassy in Bangladesh, I'm not sure how many they have, but it's a heavier immigration flow. So you are potentially still looking at about year and a half. It's typical for most of the countries. Bangladesh, I'm assuming it might be a little bit of a longer wait, but again, the best source of information whenever it comes to the interview wait time in a specific country after the immigrant visa becomes available is someone who is in that country, who recently had their interview scheduled. So if someone is from Bangladesh, I would and had their immigrant visa scheduled, I would really appreciate you commenting on Raina's comment and letting that person know how long you waited, because that's the best source of information, because it really it all depends now on the US Embassy and how busy they are, what their scheduling looks like. So thank you everyone for asking your questions. Hopefully my answers were helpful. As always, if you have any follow-up questions, don't hesitate to ask them in the comments below. Just make sure not to ask them, don't respond to my comment within your comment, because I will not see it. YouTube does not send me those notifications for some reason. So just submit it as a separate comment and it will show up once again on my wall. So thank you very much for watching. God bless, and I'll see you all in the next video.